attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the second segment in a multi-part securities lawcast discussing reverse merger transactions. In the first segment, I explained what a reverse merger transaction is and broadly described the confidentiality agreement and letter of intent. Today, I am talking about the definitive agreement used in the transaction. The reverse merger contract is usually called either a share exchange agreement or a merger agreement. For today, I'm going to call it a merger agreement. In a nutshell, the merger agreement sets out the financial terms and legal rights and obligations of the parties with respect to the transaction. The merger agreement sets forth closing procedures, pre-closing conditions, post-closing obligations, and sets out representations and warranties by all parties and the rights and remedies if these representations or warranties prove inaccurate. The main components of the merger agreement are, first, the representations and warranties. All parties make reps and warranties. Reps and warranties include a wide array of facts such as regarding the company's capital structure and corporate existence, legal capacity and authority to enter into a binding contract, the company's assets and liabilities, that there are no undisclosed liabilities, pending or potential litigation, that taxes are paid, and that there are no issues with employees. Again, this is just examples. The second area is covenants. Covenants govern the parties' actions for a period prior to and following closing. An example of a covenant is that the parties must continue to operate their businesses in the ordinary course and maintain assets pending closing. Another covenant would be to perform a stock split or a name change either pre or post-closing. All covenants require good faith in completion. The third area of the merger agreement is conditions. Conditions generally refer to pre-closing conditions such as shareholder and board consents, or if necessary third-party consents need to be obtained, or that proper documentation needs to be signed. If all condition precedents are not met, the parties can generally cancel the transaction. The fourth area is indemnification and remedies. Indemnification and remedies provide the rights and remedies of the parties in the event of a breach of the agreement, including a breach in the accuracy of the representations and warranties. The last area is the schedules. Schedules provide the details of the broader disclosures in the agreement, such as a complete list of assets, complete list of liabilities, and a list of all of the equity holders. In the event that the parties have not previously entered into a letter of intent or a confidentiality agreement, confidentiality provisions may be included in the merger agreement. The merger agreement may also contain due diligence provisions, breakup fees, no-shop provisions, non-compete provisions, and a wide variety of other agreements if they're not provided for separately. Once the merger agreement is completed and the closing preconditions are satisfied, the transaction will close and the company will file a Form 8K or Super 8K with the SEC. In the next segment on this topic, I will talk about the cost to acquire a controlling interest in a public shell and to complete a reverse merger transaction. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about any of the information we've just covered, please visit Securities Law Blog or contact me directly. Inquiries of a technical nature are always encouraged.